Hi, my name is Nick Weiss. I am the owner, founder, and supervising attorney of MP Weiss Law in South Euclid, Ohio, serving the greater Cleveland area. I want to talk today about residential leases. They seem fairly straightforward, but there are some nuances and some tricks that can trip up both landlords and tenants, particularly in Ohio. Residential leases do not have to be in writing, but it is best practice that they do be in writing so everybody knows what their rights and obligations are on this. But if you decide that you want it to be in writing, there are some essential terms that have to be on that lease, right? If it is an entity that owns the property or a property management company that is doing the management for the property, that entity's contact information needs to be on there, right? A place where they can receive mail, a person to send that mail, a phone number. If that information is not on there, we've not given the appropriate contact info for the actual entity that is in charge of this lease, the landlord waives a couple of rights. One of the rights that it waives is notice. A tenant, if something is wrong in the property, has to let the landlord know about it, right? If their heat doesn't work, if they don't have water, right? They have to let the landlord know, and under ordinary circumstances, the landlord has up to 30 days or a reasonable time period, whatever is shorter, to fix that defect. And if they don't, a tenant can terminate the lease, they can escrow their rent, or they can bring a lawsuit for that failure to do the thing, to cure that defect up to 30 days. If you don't have that contact information for the actual entity on the lease, you waive your right to notice. The tenant doesn't have to let you know about that defect before they take that action, before they terminate the lease and move out, before they escrow their rent with the court, or before they sue you for that defect that you didn't fix. You have waived your right to be notified about that defect and given time to cure it before that tenant takes legal action, right? This seems elementary, but too often we have landlords who are trying to limit their exposure, limit their liability by using a series of entities. We also advise landlords to do that, to limit your exposure and limit your liability by using entities. But there are responsibilities that go along with it. And one of them is appropriate contact information for that entity on the lease itself, or you waive your right to even be notified that there's a problem. If you've got a problem with your lease, you've got a problem with your tenant, feel free, give us a call, make sure your lease is up to date, make sure it has the appropriate information, and avoid having legal issues occur to you without you even knowing about them.